Abusian phoneti for hire for 1G. And I know first time I so I needed no book and so now I subscribe and mine. Say in your news be a no she be having notification of phone so no I be shuffling some of so be share more than for so and you be for me and Kens and so thing. A year chaka na aba bontin lawyer named the 4 pound penny aba bontin air case. Near my cause Supreme Court nina no from a year J men's as okusi a year name rim a year of your marking case no. The nyina totally unfair. Didn't know kasa or say totally wrong. Sa rule na kosu kuka nyina kosu no totally wrong. Owe no e no twas no can say arms be a organ and arms of government be a BBM no. They are not above the constitution or some don't respect the constitution. It actually is gamba being the betuja. Now should the chief that took on the betuja na. According to the constitution a parliament no. I says a chief just took on any now for your markets in him no any can say any court also made them on interfere a year back ruling because of parliament no say him the intia a back I have for your markets at times are some at the Supreme Court or you know and they found the good Mensa any mass because election be a course or constituency be no I say and you could see our constituency chrono say and dear near my course or na en your cry. Because
of time, what's the update in getting justice for them?
The update is that there is an appeal to the Court of Appeal. We're trying to get the record settled because, you know, from the point of view of the people of Sao and the petitioners that I've been representing, even if it's no longer going to be possible to hold a by-election and correct that obvious cardinal sin, for the record, it needs to be established that that constituency election was not a valid election. I think for them, it would be at least a measure of justice for that determination to be made in the Court of Appeal.
All right. Finally, on the image of the judiciary, very quickly, the Speaker of Parliament, when he last met the press, said that the executive and the judiciary were working together to frustrate the business of Parliament. What's happening with the anti-gay bill in Parliament and whatnot?
I'm not aware of exactly what the Speaker of Parliament said in relation to what you are describing, and I don't easily go in for conspiracy theories.
Okay.
So until I know exactly what was being said, I'm not able to comment on that. What I have been insistent on, as you will have heard me emphasize, is that whether it's the executive, whether it's Parliament, whether it's the Supreme Court, we must all be intent on examining their conduct in the light of the Constitution.
All right.
And what the Constitution requires each of them to do. Where they each fall short, they need to be held to account. And they need to be held to account by us, the citizens.
Okay, but what do you make of the president blocking the transition of the bill to him?
Well, again, the rules of Parliament are clear about the processes for bills being sent to the president and so on. If those processes are followed and the president refuses to accept a bill, of course that's not in line with what the Constitution's clear language requires. But as I say, I don't know the circumstances. And, I don't like to speak out of turn about things that I don't have the full facts on.
That's fine.
In terms of the procedure for bills being sent from the president, it's very clear-cut. The president doesn't have a discretion when bills have been, passed by Parliament. He doesn't have a discretion whether to accept or not to accept. He has certain powers in terms of whether he wants a reconsideration and how he can refer matters to Council of State and so on and so forth, and even let it go back to the Parliament for them to reconsider. He has those opportunities, but he can't just refuse, in respect of any bill. So I think that this again emphasizes what I have been highlighting, that all of us must have an interest and must really ensure that no arm of government is putting itself above the Constitution.
Okay.
Because that is a road to tyranny and not democracy.
Okay, my final question before we get a bit personal, I want us to talk about Article 1281 of the Constitution. Currently,
what does it say?
About the minimum number of judges that we can have at the Supreme Court, which is 9 plus the Chief Justice. The Chief Justice, like many predecessors, have said that there's a caseload at the Supreme Court. And so you have cases like the Domelovo case and that of the COVID restrictions, which they eventually ruled were unconstitutional acts by the president. But there was nothing that could have been done about it because the harm has already been done. Will you support a constitutional amendment to increase the ceiling of the number of Supreme Court judges? Because as it stands, we do not have it.
The Supreme Court at the moment, I mean, the constitutional provisions do not provide a ceiling, by the way. There's no ceiling. But
minimum.
Yeah, but I want to go back. You know, the Domelovo case, the reason why it wasn't heard early, I don't think it's caseload. It's not a matter of caseload because there are many other matters that were heard in that time. And if a priority had been placed on that, you know, I mean, take this Afenyo Markin's case. I mean, look at constituency. So they are now taking a position contrary to what the electoral, to what the Attorney General is saying. And at the same time, in the whole High Court, they were maintaining that the CI the constitutional instrument which the Attorney General had been relying on, they were maintaining that that CI should rather have been used for the election and not the CI 95, which is the CI under which these people were part of Hohoe constituency. Now, again, you know, simple reality. CI 95 was, you know, put into force in 2016. The Constitution has a clear provision, Article 47.5, which says that you can review the press release that CI 128 was not really enforced. They continue to rely on that CI in the whole High Court. And because of that, the whole High Court said that the issue about the validity of CI 128 is a matter that is not within the High Court's jurisdiction, which of course again is wrong based on all the decisions of the Supreme Court, which show clearly that the High Court is where these matters have to be determined. And the High Court should apply the Constitution. There was no dispute about the interpretation of Article 47.5 of the Constitution, so it was very clear. The final point in relation to SAL that you ought to be aware of, you know, people who try to justify the situation about SAL rely on the fact that the SAL areas have been moved into the OT region. And because there's, again, a constitutional provision which says that you can't have a constituency which sits in two regions, therefore, they cannot be part of Hohoe constituency, which is in Volta region. But again, that is simply wrong because when you look at the constitutional instrument 112, which the president used to create the OT, language is straightforward and clear. The language of that provision says OT region shall comprise the districts specified in the schedule to this instrument. Now, you go to the schedule, the districts are specified 1, 2, 3, 8. Then in 9, it says Sancho Kofi, Akpafu, Lolobi, Likpe, traditional areas. those traditional areas, as the Electoral Commission admitted in the case in Ho, were not a district. And they were not part of a district at that time. They were part of the Hohwe municipality. They were not part of a district in the OT region or anything like that. So basically, just interpreting that constitutional instrument which created OT region, South traditional areas are not part of OT region. That's just clear in the language of the instrument.
All right.
Because any ruling a chief just took on any other 5 judges normal sideline wait on no a totally wrong. A totally wrong. I just say wakoya this more me pa. We know and I can say on chief judge took on say on Supreme Court say. How come say dom level case by man shokran can say no up to now that's why I go. Nenzo afanya mark in same way by na kikirikiresi and the one now crampo according to a judicial say and the one now crampo and on matana san say yebeka LGBTQ plus na yebeka me the person yebeka speaker bambabin cancer or mass and the building in our commands or akasa bed or besign no anquisition no a chief that took on ama montema mekashi the other 5 judges now most alignment on a year after your markings compono, Mamma Bonting, I'm a cashier and fasa a year gay guinea lesbian sense and home bill no. Oreno and I'll preach about a 24-hour economy kaka. Now, I defy a year number of judges a year Becca 18 right now, Fenny 15. As I go for the trickle count money 18 no. Not chief just to corner air catch I go for the say, was saying any put to account. Thank I had 20 no. I don't ever can tell you check I but good name as a pa or say. And you pound do a fancy 55, nipa 100, nipa 1,000. A do case was nipa senate as our case no so 7 pay. So 20 now doing and all the day. Was I was saying a sucampu so as I take out. Na chief just the head air pressure ko fa some from bro was say and catching crampone dey don't come elected new president come put no me dey some dey bound be yaba now say pressure we no and the fire poor governance e ko say akofa do ni man ni any lu tension na dey na o ka on some just na e ya dey just na enya sa good come ni good teacher to yaba ni dey
the record time in which it was heard with not even hours, so I think that we must all be clear that these issues about caseload, I see many judges in the court below, the court, like the High Court, also talk about caseload. I mean, you go to court as a lawyer in a High Court, you see many, lawyers waiting for their cases to be heard, and often it doesn't get to their turn and so on. If we're going to talk about caseload in the court, we look within the whole court system. And so I don't frankly appreciate this attempt to, make the caseload of the Supreme Court a thing in itself. If we're going to look at caseload, we've got to look at it in terms of the court system globally, and whether we're going to have a 24-hour court sittings like the 24-hour economy, or whatever it's going to ensure that there is more, activity in the courts that meets the caseload. But I don't think that one can separate the matter of the Supreme Court. Now, as far as the numbers of judges in the Supreme Court, again, my view is that the Supreme Court, currently constituted, has probably, I think now about almost 18
judges.
About 18 judges. Now, again, as lawyers, we observe that when the court is sitting, the court doesn't even sit all days of the week. And when the court is sitting, only a certain number of judges are sitting. So many of the 18 are actually not sitting. And I mean, it's difficult with that to say that they need an increase in the numbers. I know that the Chief Justice proposed, I think sometime in July, that there should be an increase to 20 from the 15 that was conventionally, But fortunately for us, the Judicial Council took a position against that because the Judicial Council did not feel that even the timing was right. Because in effect, you would have a situation where an outgoing president is making appointments to the Supreme Court, which will put on the Supreme Court judges who will be there until they are 70. An outgoing president, again, a previous Chief Justice had said when, I think it was President Mahama, who had tried to appoint members of the Supreme Court when it was not even yet 15. A previous Chief Justice had said, with this timing, it's getting close to elections, it's better to wait, let the next president come in and make these appointments. But here we have a situation where this Chief Justice, regardless of that previous precedent, was trying to push the Judicial Council into having appointments made. And I say the Chief Justice because she had initiated a memo to the President as far back as in February, in which she was trying to use the caseload justification and so on and so forth. So in the end, the Judicial Council said, no, let's halt. It's close to elections. Let the new president come and consider this. And I think that was the right position that the Judicial Council took. I think it would have looked really, unfair and misused, frankly, of the powers of the president.
So should we put a cap on the number of judges, Supreme Court judges?
I don't think it's necessary to have a formal cap. There are things that people should not require a strict legal sort of instrument or a strict constitutional provision before they go according to them. I think that we sometimes overemphasize what can be achieved through changing the law or reviewing something in the Constitution. Some of the time, the problems we're dealing with are just problems of poor governance by people who have been elected to certain offices or have been appointed to certain offices and who are expected to use their judgment in ways that are beneficial to the national interest. If they don't do that, it's not the law that is at fault. It's not the provisions in the Constitution that are at fault. It is the people. We should hold them accountable. That should be our first point of reference. Of course, there are things that may require modification and so on in the Constitution, and there's been a whole review committee set up, and they've come up with recommendations which, have still not been really looked at closely. But I think sometimes these arguments about Constitution being reviewed and so on, they...
for any information about to announce or semeti for Pemasem no, ye mamtisa Newz Nyasem so Yembo Chaka and Simon Kaka. Yedefa Udi say Tim Nimbo in Sem Kaka, Edifa a dom level case now to say Ocheche Nami won't say a chief that took on any Supreme Court for Ninano, and there's a semi bed down up to now, that's what they hang over. Nanzo so after Marcus Kesi by day will be half and Kukuni Kaka Station in tea. I got now a year back and quarter, Eke Candy Mope, and all kinds of near course on a totally wrong. And dear Omadi the air court appeal court because near don't obey the obedience and Natias H. Now, edify a year. Number of judges are not a chief that took on a recommendation common saying any part a 2 abeka a 18 or 20 no and I beka chaka edin first school makakara because I say a year from your man's case never dog campo mobuno than time campuno a dear and any part 18 in an etnaso any past 7 penetnaso so much as 7 Nasa ruling for Froba, Nasa Anguia, no the 2 hour account 9 omo na according to all numbers. So that 20 now open what the 20 near day because na 15 elbia na 1000 kakra was me saying ni patria account na as I 18 right as me saying ni per 2 and all can say niema ye beka chief justice dukono ye Supreme Court enya de efa kwem krampo na arms of government ni nyina no or some respect the constitution or we know another fa ye beka jemensa ni me bia o ye by election be course or constituency be entwa ye nyina no ye beka to do chaka de record nyina ekeka mu asem chichi ni mamu se jemensa ye de anye ni ye Supreme Court enso anye ni ye election e course 2020 so na me bebre wo ma so man de o manye ni chichi mo se preach about 24 hour economy no ke kan se me bra je se bit man de ache adwen e wo comment session bi kwa minti min kan ya betimi so ahia ma dan so enye bi ahwe Alpha 1G